Exclusive with your host, Stu Peters.
Welcome to Patriotically Correct. I'm Stu Peters. I'm here with attorney Kenneth Ferguson, a Florida attorney embattled by what appears to me to be some of the deepest and most widespread judicial corruption ever exposed on a national platform like this one. Ferguson's going to be presenting some evidence, making it unnecessary for you to believe his words or him, and he'll quite literally be risking it all by going on the record today. If Ferguson is lying, essentially, there could be serious implications, but after seeing the evidence, you'll know the truth. The damning proof that involves what appears to be nefarious and illegal actions by sitting district court judges. Ferguson's been to every Florida state court with this case, the Florida State Appellate Court and to the Florida Supreme Court. He's been in front of every federal court that this case can reach, leaving only the Supreme Court of the United States, which is where it sounds like you're headed next. Thank you for your bravery. It's admirable, and appreciate you being here.
Appreciate you having me on. Thank you.
I'm looking at your most recent filing to the Florida Supreme Court. In here you write, when courts are regularly departing from even the most basic rules of civil and appellate procedure and entering patently unlawful or contradictory orders that always result in outcomes to your client's detriment, bad for your client, most often stemming from clear misstatements of law, being made with impunity by opposing counsel. They're lying. That's what I'm reading here. There's cause for real concern. So for clarity, you write, what you believe is occurring is not the defense making good faith efforts to extend the law or inadvertently misstating the same, and it's not the trial and appellate courts merely getting it wrong, but collusive judicial advocacy to ensure adverse results and protracted delays in your client's litigation.
Got it.
So while your client has some ideas and while you have some ideas why this may be happening, whatever the reason, it needs to stop, which I agree with, as the repercussions of Florida courts sanctioning prestigious large firms' misrepresentations of law to subvert your efforts in court. I mean, you're calling out the entire judiciary here.
I am.
What is going on?
Stu, you're not going to hear attorneys say this often, but I hope I'm wrong about that. I don't want to be right. I want to believe that these courts and that what we go before are on equal footing, that we're all equal before the law as we're supposed to be.
But I mean, with all due respect, you're calling them out, but this has been filed in district court, in the Supreme Court.
Yeah.
If you are wrong, there could be some serious implications for you making these accusations. You're making the accusation in layman's terms that not only are defense attorneys lying, misrepresenting the truth, but that district court, appellate court, and state Supreme Court judges are participating in what appears to be a filibuster of sorts, that they are preventing you, they are oppressing, they are somehow colluding to make sure that this case doesn't get heard. This has been going on for years.
Yeah, I mean, I've been involved in this for 3 years now, and I have brought this to the attention of many firms, frankly, who are far more seasoned than I and attorneys, and they can't explain it. They've never heard of this happening in their careers. For roughly 3 years and over the course of about 47 cases, I've never been able to take a single deposition, never participate in discovery. In fact, these people haven't even had to answer a complaint. This is unheard of. I've never heard of it. Other attorneys have brought this before, I've never heard of it. And the only thing that I can explain right now, or at least that I can think of, is that something is going on behind the scenes. There's some shadow.
It's plain to see. It's corruption.
I mean, there's some shadow activities happening because nothing can possibly explain how members of the bar, Florida bar, are making patent misstatements of law, and judges are allowing this to happen. I mean, case law is clear, and it's obvious. Judges are lawyers first. You know, they have to be lawyers, and as members of the bar, we're a self-regulated agency. Mm-hmm. So if I'm misrepresenting the law, they have an obligation to report it.
Right. And
none of that's happening. They're allowing this to happen, and not only that, these orders are being entered that are adverse to my client's interest, and this has been going on for 3 years now.
Now, you caught my attention originally on Telegram, which is a social media app that is kind of bolstered itself after the shadow banning and deletion of accounts on Twitter. People are moving around trying to get heard. And you just simply asked me, hey, if I want to send you some stuff that you may be interested in, where can I send it? I provided you with my email address, and you sent me over documentation. I mean, this is minuscule. This is a very small amount as compared to the totality of what you have going on here, and we're going to dive into that. It was hard for me to understand initially because I'm not an attorney. But as I started reading more into this, and as I started talking with you on the phone prior to you flying here to Minneapolis to meet with us, it became very clear that this isn't just something that affects billionaires. This affects me, it affects them, it affects everybody, because this is pertaining to things that we do every day. We travel, we use rental cars, we travel on trains, planes, automobiles, we use hotels, lodging, and that is what this specifically deals with. And we're talking billions of dollars here. I mean, billions. I would compare it to the big tobacco cases, right? And in that case, they had manufactured or installed and created specific divisions because of the caseload. It was just such a big case. This is along those same lines as far
Absolutely.
as the magnitude and the size and who it involves.
Right.
Talking about every major airline, every hotel chain, every rental car outfit, every credit card company. So simplify it. Tell us what is going on here. Why should I be concerned about it? And then we're going to dive into what I believe is very clear-cut, widespread corruption by the judiciary.
Sure. So as far as why it should matter to you, it's twofold. So let's start with one thing that I think is interesting about this case in particular is that it has seen all aspects of the judiciary. And again, I think that what's important to understand about this is that, I think a lot of times people will hear about a case that's like, well, that's in the Supreme Court, that'll never affect me. But these are elected officials, in your cities. I mean, we're going to talk about it later, but in 7 major cities in Florida, our case has been before. These are your local judges. So, in Florida, if a hurricane comes through and it blows a house down and the insurance carrier doesn't want to pay, these are the same judges who are going to be ultimately determining whether or not there's going to be coverage on your house.
So they're deciding whether or not to protect you or to protect the big conglomerate billion-dollar insurance corporations that are all funded by, well, we know who. The same people that are funding mainstream media, the same people that are funding big tech, the same people that are funding most of these politicians. We have in one case somebody who's on the Congressional Intelligence Committee who was literally having sex with a Chinese spy for many years. I mean, the corruption has been revealed at that level, and you're dealing with it here.
And I think that's a good point, is that this is on a local level too. So it's not something too remote. I mean, this is in your backyard. These are the people who are making decisions, that affect you. I mean, this is your home. This is your homeowners. This is if you get into a car accident. These are the guys who are going to be determining the outcome of your case. And I think that we all can agree, I don't care if you're at the left or right, that the justice system is supposed to be impartial. There's not supposed to be a thumb on a scale. And when you look at what's happening here, it doesn't appear that to be the case.
Okay, so let's talk about the case. All right, so you're bringing what case before the courts, and you're trying to get specifically what heard as simply as possible?
Sure. So let's take a step back as to what we have. So my client is a software development company. We own software.
Okay.
And we licensed a portfolio of patents. And what those patents do is it permits, for instance, if you have a credit card and you have Amex points and you want to convert them into Delta miles, or you want to convert them into Hilton hotel points.
We do it every day. Yeah.
Of course. So anytime you transfer points across program boundaries, that's my client's software. We have that right. A good example is if you remember back in the day, Amazon used to have one-touch shopping.
Sure.
So they owned that process. They had the patent to be able to do that. They were the only ones to do that. So my client, Point Conversions, has the rights to be able to transfer these points across program boundaries.
How are they doing that? How are they infringing?
So they're allowing the transfer of points between program boundaries. So if they're, in this case, we're suing Choice Hotels. So Choice Hotels is allowing to have contracts with, MasterCard, okay? And what they do is they set up contracts to where they'll transfer points between them so that they can get hotel stays, so that the customer can get hotel stays. So that revenue is all ours. They owe us revenue for that transfer.
Revenue? How much money are we talking about here?
I'd say on a very conservative estimate, we're looking at exceedingly over $5 to $10 billion.
Billion with a B.
Right, billion with a B. And
so there's obviously motive for people to shy away from this.
Oh yeah, if you actually look some of we were looking at some of the documents that are filed with the SEC, they're the 8Ks and 10Ks, and we estimate that anywhere between 28 to 33% of their revenue comes from violating our software rights.
From cheating.
Effectively, and they know it. That's the thing.
They're cheating me, and they're cheating my wife, and they're cheating you and your family, and all of these people.
And that's the thing, right? The reason this affects the customers is because they're representing these points to you that they're fully encumbered and you can transfer these points all you want. Well, you can't. You have to use our software. So they don't warn Stu that, hey, if you end up transferring these points across these boundaries, you can get sued. So Stu can get hauled into federal court and be sued for intellectual property because they don't want to tell you about it.
So that seems to simplify things for me. I have a grasp of what's going on with the case. Let's talk about the people that you're fighting against, but first let's start with you. So you're a sole practitioner. Tell us about Ken Ferguson.
Sure. So I was born and raised in Jacksonville, Florida. Went to school at University of Florida, graduated, I was an English major there, and then went to school in South Florida, law school. I graduated, and I always say I'm a lawyer by trade, entrepreneur at heart. I went to Naples and ran a small business there, so I wanted to be a trial lawyer. I love it. I was a assistant state attorney in Gainesville, Florida for a bit, and then went off and opened up my own shop, and here we are.
Okay. The people that you're fighting against, the people defending these nefarious actions, the cheating that's going on by these hotel chains, airlines, et cetera, who are they?
Sure. So there's two main firms that are involved. One of them, and we'll refer to them as Reed Smith, is one. They are a 20, probably top 20 largest firm in the world.
Yeah.
I think they have over 1,500 attorneys. They boasted revenues last year about 1.17 billion, I think is what it was.
Wow.
And yeah, Ferguson Law, we're not there yet, but we strive. We think we're going to get there close.
Okay.
But yeah, so suffice to say, they're not shy on resources. The other one is another firm called Schutz & Bowen. They're a local firm in Florida, but they're in every major city. Again, not shy on resource. Something that
and you name them here in your most recent filing with the Supreme Court as making misstatements of law with what appears to be impunity. So we'll get into that a little bit more in specifics, but the first law firm that you mentioned is a familiar name. And maybe our listeners don't know why it's familiar, but how about some of the people that they've represented?
Sure. So after Robert Mueller conducted his investigation with President Trump, they were the firm who represented the Russians who were indicted from that investigation. They're a big deal. I mean, they're international. They're in, I think, like over 10 different countries worldwide.
I refer to these people that you're talking about, Mueller and the people behind this collusion narrative, as members of the deep state. Okay, and a lot of our listeners are familiar with what that means as well. I'm sure that you've heard the terminology.
Sure.
These are the people that sit at this, what I call a global imaginary or maybe even a physical round table. They fund people like Amazon that you mentioned earlier. They fund the big box stores. They fund big media, big tech. These are the people who have unlimited resources, unlimited funding. These are the people like this law firm are being funded by the same people. One could speculate. They're defending the actions of people who were indicted to commit crimes against our country. Right?
I mean, these are the same guys, and mind you, just on this case alone, they had about, I think it was 7 or 8 attorneys from Reed Smith, and there's 8 attorneys from Schutz & Bowen, and they have their assistants, they have their paralegals, they have their associates.
So you're talking roughly 15 to 18 attorneys plus their staff. I mean, you're one person with your client treading water uphill, fighting against unlimited money and a whole lot of resources. So you get into court with this and take us here to the Stonewall.
Yeah, so we filed our complaints in March of 2019. And to date, I have not had any deposition taken. I have not been able to get any discovery. They have not had to answer. They have not had to do anything that, in the normal discourse of a lawsuit, this stuff comes immediately. It's coming within 30 days, 60 days tops. And yet, here I am, I've filed over 40 appeals. I've been into every state court in Florida, I've been in federal court, and I can't advance this case at all.
When you say you can't, why can't you?
For whatever reason, these judges are saying we don't have the authority to be able to hear it. But what should become obvious, well, someone has to, right? I mean, we have a constitutional right to a jury trial. I mean, that's actually one of the only guarantees in the Constitution that's both in the Constitution and in the Bill of Rights, that we have a right to a jury trial. My client has a right to be heard in court, to have his grievance heard. And to date, we can't get heard. Now, we filed suit initially, and we'll talk about it in a bit, but we filed suit in state court, And a federal judge said this case doesn't belong there, and we agree, she's right. So if it's not in state court or federal court, it's got to be in state court, because if it's not here, then where? And presently, for over 2 years, they're not allowing us to advance our case, and it really is concerning why that is.
Okay, so when you say not allowing, are they giving this to you in writing? Are they saying this on the record? Are they blatantly just saying, nope, we're not going to hear it?
Right. So what happens is for your listeners and audience, so when you file a lawsuit, it's kind of like a game of ping pong. I file something, then you go, and then we go back and forth.
Right.
So we filed our complaint, and they tried to move to dismiss our case. That means throw it out for something called lack of subject matter jurisdiction. And I'm not going to get too legalistic with this, but this is a very important concept to understand. You can substitute the word subject matter jurisdiction for authority.
Okay.
Do they have the authority to hear this case? That is all this is about. A federal court's already said, federal court can't hear this. We don't have the authority. This is a state claim. We're trying to enforce a state license. We only hear a certain type of case. The state court are saying, well, we can't hear this because this deals with patents. Well, Supreme Court has said for decades, in fact over 100 years, that just because there's a patent issue in a state cause of action, that doesn't mean you can't hear it. And these are, again, the most prestigious firms in the world. They know this, but yet they're continuing to advance these claims, and these judges all know this too. And yet for every court, and as we'll discuss later, it's across 7 cities, they have granted their motion to dismiss, saying we don't have the authority to hear it. And they're not abiding by black letter law, or they're not abiding by case law from the U.S. Supreme Court.
This is like the little kid who's being disciplined, right? They're in trouble, they don't want to be scolded, so they make a bunch of noise, they cover their eyes, they plug their ears. I just don't want to hear this. And it seems like that's what you're up against here.
It certainly looks that way.
Now, the homework that I've done here, first of all, and any time that you're looking at corruption or crime or just nefarious activity, you always look at who has what to gain. What motive do I have to participate in this activity?
Who benefits, right?
Right, sure, who benefits from what? Money is a big one. That's probably the root of all of it. Doing some homework here, it looks like these 4 airline companies alone value their rewards point systems at over $77 billion, with a B, billion.
77 billion, yeah.
That's more than the value of the airlines themselves, the entities combined.
Yeah, the reward companies are worth more than the actual airlines, and that's true for almost all these major companies, yeah.
And you've tried to make noise. We'll talk about that. First, according to Wikipedia, let's talk about Reed Smith. This is the law firm that we were talking about. They were founded in Pittsburgh in 1877 by Philander Knox and James Reed. The 2 partners created a relationship with American industrial tycoon Andrew Carnegie.
Andrew Carnegie.
Very familiar names here. Heinz Company, South Fork Fishing and Hunting Club, the Bank of New York Mellon, Henry Clay Frick. These are, we're talking about, some seriously big mogul type names. We're talking like Rothschilds type familiarity here. And then Schutz, these are the people that you mentioned, Schutz and Bowen, you mentioned them in your most recent filing with the Florida Supreme Court as misrepresenting the law, what I would just call it lying. In 1910, Schutz organized the Miami Herald Publishing Company. I found that to be really interesting. Now, you've tried to make noise with this. You've gone to the Miami Herald, you've gone to all types of different news outlets in South Florida. Nobody wants to talk about this.
No one will cover it. I've reached out to about 7 outlets and can't get anyone to bite. And this is, again, I'm going on record saying this. This is not something I'm very comfortable saying, but this is the potentially most widespread judicial collusion as to what seems to be to subvert my client's efforts, and that's not newsworthy. I find that very difficult to believe. I think that's something that people would want to know, and I can't get anyone to cover this.
Going back to this filing, okay, you lay it all out. You say that there's cause for real concern, and then you say, for clarity, what you believe is occurring is that Schutz and Reed, Reed Smith, are lying. And that these are misrepresentations of law. So the courts are saying, we can't hear this. We don't have the authority, or you referred to it as...
subject matter jurisdiction. It's one and the same, yes.
We don't have the authority to hear this at the state level. This is a federal issue. And the federal court is saying, no, this has to be heard at the state level. The state level is saying, but this involves patents. Everybody knows at Schutz and at Reed Smith that it doesn't matter that it involves patents. They're required to hear it.
Yeah, they do know that. And what's interesting is I'm going to take you back to the beginning of the litigation, because Reed Smith was the first firm that was representing what we call our test case. So our first case was filed back in March of 2018, 3 years ago. Okay, we filed our first case in Broward County, basically small claims court. Okay, so we filed our claim there, and the defense, Reed Smith, tried to say, no, this case doesn't belong here because patent issues have to be decided. It was removed. They said, nope, this belongs in federal court. So we went to federal court, and the Southern District of Florida, the federal judge there, said, nope, we agree with my client, or our position, and they sent the case back down. It's called a remand. So they sent it back down to state court. So Reed Smith and Schutz, they are representing that same client. So they know that the cases belong in state court because they were the firm who tried to remove it and send it to federal court to begin with. So I keep asking all these state judges, I've been to 7 different cities across the state of Florida, all saying the same thing. I say, Judge, if a federal court has already told us that it doesn't belong there, then it must belong in state court. Because if not here, then where? We have a right to be heard. So if it's not in federal court, then it has to be here. And yet, to date, I can't get our case heard after 2 years.
So what happens when you go to each one of these different cities? You have a map here. You've circled the 7 counties, Duval, Alachua, Pinellas, Hillsborough, Palm Beach, Broward, Miami-Dade. Your test case went to Broward County. So let's start there. I mean, what happens when you go to these places?
Sure. So we followed our first test case to just see if it would, to see where it would fall. In other words, we didn't want to file a whole bunch of cases. We wanted to start with just one to see if it would pass legal muster, okay? So once we heard from the federal judge, they said, hey, this case belongs in state court. We filed 46 more across 7 different cities in Florida.
46?
46 different cases. And so whenever a case is filed, it's going to be distributed to all different judges, right? Mm-hmm. Miraculously, every one of our cases have all been consolidated and sent or consolidated or transferred to one judge in every one of these cities. And oftentimes they don't even follow the law.
Is that unprecedented?
Some cities, yes, but it's incredibly unprecedented for what happened in Broward County, and that's what I'm going to get to. So in Broward County, for instance, and remember, this is where our test case was, and oftentimes the way it works is if you have 10 cases in one particular county, obviously, if you're going to consolidate them or just want to have one judge hear it for judicial efficiency and economy, it makes sense. It really does. So you transfer it to the lowest case number. So we filed 10 cases total in Broward County, and the lowest case number is not the judge who currently presides over them.
Okay, so these are arbitrary numbers. This is like a lottery. It's like a drawing.
Correct.
Okay, if your number is called, you're the judge assigned to it.
Correct.
Okay, but these numbers don't line up in this case?
No, and that's what's again.
So this was hand-picked.
Well, you got it. So this is how it works. So again, they're randomly assigned.
This is very important. This was supposed to go to a judge based on just the way a number falls.
An objective number. That's why I was telling you, you don't have to believe anything I say. You can literally look at this and say, which one's the lowest case number?
Okay.
And somehow they didn't go to the right person.
They were hand selected.
So that's what seems to be happening. I mean, another way, I'll just come out and say it, it looked like they were judge shopping.
Okay.
And I don't know, look.
I mean, that's what it's obvious.
Yeah, I mean, I'm not I was relatively new in the South Florida area. I didn't care which judge it was. I was like, all right, go to the lowest case number. I don't care. But the defense was highly lobbying to have a particular judge, Judge Lopane, to hear this case.
Okay.
That's concerning. Like, why would someone want this judge particularly this judge to preside over the case? And I think it became very obvious why, and I'm going to get into that later. But suffice to say, obviously, if the test case was filed first, that's going to be the lowest case number, so everything should be transferred there. So for, I don't know, probably 6 weeks, arguing with defense counsel about, hey, why aren't we just going to the lowest case number? And they literally lied to the courts about what the law states, who they know what the law is, in order to get the cases transferred to Judge Lopane. And
so they're lying to the courts, okay? They know they're lying. The courts have to know they're lying.
Of course.
These judges were attorneys before. They're well practiced. They're scholars of the law, right? At least that's what we would like to think.
Sure.
The law is objective. You're lying to me in my courtroom about the law. I know about the law and know you're not getting your way. What happened to that?
Right. Well, I tell you, I walked in there and I said, Judge, I'm looking at Administrative Order 100, which is what it is in Broward County. It says, in order to file or to transfer cases or consolidate them, you need to have a notice filed in all the cases, a motion filed in the lowest number, and you have to set a hearing. And again, all the dockets speak for themselves. Not one notice was filed in the cases. The motion that was filed before Judge Lopine, they withdrew it. And you want to know why? Because if you read their motion, it says it should have gone to a whole other court. So the defense even said, hey, this is supposed to go somewhere else, because it was, but they withdrew it because they wanted him to have it. At least that's my opinion.
Why did they why would you speculate that they wanted Judge Lopine to have it?
Well, I didn't know at the time, quite frankly, but I can tell you that since we've been involved in these cases in South Florida with him presiding over them, there has not been one motion or request that Schutz has asked that he has not granted. In fact, there's been times on the record that you could see where they had come to the court with orders and they're just being signed carte blanche. Sometimes they're not even looked at. On the record one time, in fact, I wasn't even present in the courtroom and it was signed. So literally anything that they have advanced, whether it comports with the law or not, it's being signed carte blanche, and it's always to our client's detriment.
Jonathan Gerber, a former partner in the West Palm Beach office of Schutz & Bowen, became a Palm Beach County court judge from 2002 to 2004, then a circuit court judge from 2004 to 2009, and on April 7th of 2009, Florida Governor Charlie Crist appointed him to the Florida 4th District Court of Appeal. These judges know each other. It's a small world.
Yeah, there's a saying, it's judges talk. They know what's going on. Again, these 10 judges presided over 10 point conversions cases. And then they were all, and this is what's so crazy. So, there was no motion filed, no notice, no hearing. So Judge Lopine is a circuit court judge along with the other 10, okay? They're equal power, they're equal authority. He sua sponte, that's a fancy word for I do it on my own, took the cases from the other court's dockets and just gave them to himself. And I actually showed up and I said, Judge, what gives you the authority to be able to do this? You can, again, the transcript, he was kind of at a loss for words. He said, I know there's a rule out there that says you're allowed to, consolidate them. I said, yes, Judge, but according to your hearing transcript, you said this wasn't a consolidation, it was just a transfer. There's a difference. And I said, Your Honor, what gives you the authority to do this? I don't know, if you have a problem, take it to the 4th, is what he told me.
Which would be the 4th District?
Right, so if I have a problem with the trial court order, it goes to the appellate court, the higher court.
Okay, so then did you?
Absolutely.
And then what?
So I came out and said it. I said, they're not complying with the law. This isn't the lowest case number. Here's the order. I said, 4th District Court of Appeal, don't allow this to happen. Distribute the cases the way they're supposed to. And a recurring theme that you're going to see throughout these cases is they just deny what I ask without any explanation. So I said, this is wrong. This is what, this practice is not lawful. It doesn't comport with the law. And they said denied, no reason. So.
Now your client, according to this affidavit, is the inventor of approximately 100 patents. For the last decade, he's prosecuted patent law, Fortune 500 companies, IBM, Motorola, Ericsson. He's no stranger to what it is that you're dealing with.
Brian, he's started off as a client, now a friend, but he's a rock star with patents. He knows his stuff.
When he's talking here, and this is under penalty of perjury. I mean, this is a sworn...
It's a sworn affidavit under penalty of perjury that what he's saying, he believes it to be true.
And he said, with the utmost respect, we're asking that Judge Lopine in Broward County recuse himself or be disqualified so that he can ensure that he receives fair treatment and partial rulings in their cases before a neutral judge, or preferably neutral judges that were initially assigned. So, in other words, the lowest number goes here.
Right, well, remember when I said before, I said, look, when we filed these cases, they went to 10 different judges. So we would rather just say, hey, look, let it go back to the 10 judges that they were originally assigned and let the chips fall where they're made. We're not looking for any favors. We're just looking for judges to call balls and strikes. That's all.
Not one who we believe has bias, prejudice, and has a defense-centric agenda. You believe, and your client believes, that the defense violated procedure and law to quite literally handpick Judge Lopine, and the record and transcripts indicate the same.
Correct.
I mean, this is mind-boggling stuff. So this has been filed.
Oh yeah, and so we moved to disqualify, and we met all the procedural standards. And to just give you an idea about how low this standard is, in other words, All we have to do is show that there is a reason to believe that my client has a reasonable belief that there's bias, or that he doesn't believe that he can get a fair trial. So after reading and seeing what you've seen, after a defense literally handpicks the judge, would that give you at least a reasonable belief or concern you're not going to get a fair trial?
Your client believes so too, concerning and especially suspect, considering a small entity like your client and a sole practitioner, you, acting as his counsel, have been challenging the extremely lucrative and pervasive practices of a Goliath company like Choice Hotels, which for all practical purposes has an unlimited budget and willing to leverage and do whatever it takes to stop you because of their immense profits they make from the inventions of the patents that we're talking about with this software.
Absolutely.
Okay, so this says to me that there's two things that could happen here. Why are the reasons why you believe that Judge Lopain could have been handpicked?
I mean, it seems to me that, for one reason, it's that they knew that he would be willing to do whatever it takes, or whatever frankly,
because
what
why?
they wanted
Because
to.
they don't want to rule on this type of law. Because
Right, well, I mean, to be frank, I don't know exactly why. That's something we should probably find out from the judges themselves. So I don't want to speak on their behalf, but I can tell you that this case is a hot potato, so to speak. I mean, nobody really wants to adjudicate this because this is novel. This is the first time that this has happened on such a wide scale.
Well, we talked about the tobacco case and how they created an entire division to deal with this stuff because judges really didn't know what to do with it, right?
Right.
Shouldn't they do the same thing here?
That's a good point. So maybe one reason that they're not wanting to rule on these is because historically, any sort of patent infringement like cases where you have to determine patents and infringement and validity and things like that, that's ordinarily handled in federal court. But we've been able to bring all these types of issues into state court, and maybe that's a reason that they don't want to deal with it.
Maybe the other reason they don't want to deal with it is because their pockets are being greased. Maybe they're being bribed. Have you ever heard of the inflation of bribery? It would apply here. Hillsborough County.
Yeah, Hillsborough. So interestingly about Hillsborough is the judge who presided over that, he actually wrote a Florida bar article on subject matter jurisdiction. So if there's one person who knows about this topic, it's him. And interestingly enough, he says that
whether or not you have the authority to hear the
whether
case.
he has the authority to hear this case, right? And in his article, you can see it here on, have him pull it up. He even says that litigating subject matter jurisdiction should not be costly because it's obvious that if a court of limited jurisdiction like a federal court can't hear it, then obviously the one of general jurisdiction of a state does. And yet here we are 2 years later, millions of dollars, not only of point conversions and the defense's money, but think about all the taxpayer money that's going into this, all the judicial resources. Florida complains all the time about how overcrowded the dockets are and how it's backlogged. Well, it's really, frankly, it's their own fault.
And we're talking about in courtroom lies too, like caught. I mean, we were talking about the discrepancy between orders, how you got them, what was said on the record.
Oh yeah.
All kinds of examples that you've given me. Do you want to give some?
Yeah, so I mean, keep in mind, so we had Broward where they said, we're throwing it out for lack of subject matter jurisdiction, and Judge Lopain did not apply the law. So in 2013, there was a case called Gunn, G-U-N-N, and they laid out the 4 factors at which you have to follow. Judge Lopain didn't follow them. We then go to Hillsborough County. This is over in Tampa.
Yep.
Okay. Same motions, same responses. The judge ultimately says, well, I'm going to have you guys answer the complaint, and then you can come back and we'll talk later. Well, once you answer a complaint, guess what? The motion to dismiss is moot. This is, an attorney will know this. It's basic procedure. Mm-hmm. So what happens is we come back after our first hearing, and then we argue only subject matter jurisdiction. And then Judge Stevens argues or comes out with an order that dismisses our case for failure to state a cause of action. And in simple terms, what that means is let's say if I were to sue you for a battery, punching, and I say in my complaint that I took a swing at Stu and missed. Well, if I didn't touch you, it's not an unlawful touching. I didn't meet all of the elements to hit the crime. So I have to touch you in order to commit a battery. So he, sua sponte, on his own, says we didn't meet the causes of action in order to bring our state law claims. You can't do that. The defense has to raise that. So put in different terms, the judge is acting like a defense attorney, quite frankly. He's raising the issues on their own behalf. That's completely unlawful.
Illegal.
Sure, yeah.
It's outside of the law. It's outside of his jurisdictional authority.
Well, a judge is supposed to be neutral. He's not supposed to be raising arguments on behalf of the defense.
Stevens is no stranger to criticism and ridicule. I mean, 9 years ago, he was all over the news for making up the rules as he went along.
Hillsborough Judge Scott Stevens overstepped his authority when he tried to change the workers' compensation law. An appeals court said he abused his discretion in a family law case. And as investigative reporter Mike Deason found out, the clients and attorneys who appeared before Stevens say he has turned their lives upside down.
Scott Stevens. The judicial rating website RoadProbe says he's a very bad judge, and many people who have appeared in front of him agree.
He terrorized and punished my wife and my children and made it so that we really spent every dime we had. We spent over $500,000 on legal fees.
And clearly many of the people who appear here in family court are unhappy with the outcome in these adversarial proceedings. Many of the people who have complained to us say they believe Judge Stevens' rulings are bizarre and beyond the scope of the law. Haddock says he spent more than $400,000 winning custody of his 4-year-old son. Haddock says Stevens referred the issue to a magistrate, but then Stevens rejected the magistrate's findings and filed a bar complaint against Haddock's attorney for going to the magistrate.
He wanted the magistrate and me to explain to him why the magistrate had the jurisdiction to hold such a hearing.
But didn't the judge give the magistrate that jurisdiction?
Certainly did so, several times.
Stevens may make life miserable for some attorneys and their clients. He's done nothing that would lead to his removal from the bench. Mike Deason, 10 News.
By the way, Judge Stevens no longer hears cases where people are represented by attorneys. He only handles family law cases where both sides appear in front of him with no representation.
Yep, and I'll be frank, that's exactly what seems to be happening here. It's systemic in these cases. I can go for, we don't have enough time. We could do an entire segment on what's happened in Hillsborough County. But I can tell you, what happened with Judge Stevens and what's happened in his courtroom is very disturbing. And, it's candidly, it's disheartening and deflating to think that this is actually happening and going with carte blanche and with no accountability.
You're supposed to be officers of the court, right? You all represent the same blindfolded woman with scales.
Yeah, I like to say, I'm an attorney and so are these judges. But at the end of the day, we serve the same master. We serve the same woman. We serve the same boss. We have an obligation to uphold the law, and our boss is the same. It's a blind woman holding a set of scales. And the idea is that before the law, it's blind. It doesn't matter your money, your status, creed, color, race. Justice is supposed to be blind. There's supposed to be fingers on the scale, and we cannot get a day in court. And it is, again, very, it's been uncomfortable to talk about this, but it's gotten so bad and it's so pervasive, and that's what's become so obvious. That's why it's reached the tipping point, quite frankly. Because when I'm going to 7 cities and their respective appellate courts and the Florida Supreme Court, and I'm sitting here saying, with objective evidence, that attorneys are lying, that the judges are letting it happen, and they're not following the law, where else do I go? Where else does anybody go, quite frankly? If I can't get my day in court, if I'm watching, members of the bar, my fellow attorneys and colleagues lie, they know they're wrong. In fact, I'll even tell you about what happened in Jacksonville. After one hearing, and even the transcript reflects this, he says something to the effect of, he's like, I don't like where this is going. The judge knew we're right, he did. And then to give you an idea, and I'll swear to this, after the hearing, the attorney came up to me, Mr. Gillis, and he said, Ken, I hope you have enough money to be able to pay for these experts, because he knew he should have lost the hearing. He knows it's, that these courts have the power to hear it. So after the hearing, he kind of came up to me, he goes, hey, Joe is the other attorney. He goes, hey, Joe, how much are we paying experts every month? About $100,000. Hey, Ken, you got that kind of money? You got that kind of coin? And it's like, they know what they're doing.
They're trying to intimidate you or push you out of this by exhausting you financially and taking away all your resources.
Oh, and they don't even hide it. There's in that transcript, and I'll have it popped up for us, but you listen and hear what he says. He literally says, the judge asked him, because it's a great question. The judge says, well, wait a minute, I saw in Broward County, the test case as we called it, they just said it didn't belong in federal court. So if it doesn't belong in federal court, how do you reconcile that? And the Schutz attorney said, well, frankly, we don't have to remove it. Because I kept telling people, I said, Judge, if they really believed what they were saying, if they didn't believe it could be heard in state court, why haven't they removed it? Because that would put this to rest swiftly. Because if you remove it, they have to tell you within roughly 30 days whether it belongs in federal or state court, right? So, and you don't have to be an attorney to appreciate this. Think about it. Why, if they believe these cases can't be heard in state court, didn't they remove it to federal court? Well, because they know the answer. They know it can't be heard in federal court. But yet, for some reason, they feel comfortable making these frivolous arguments here in state court, but they don't feel comfortable making them to a federal court. And I guarantee you it's because a federal court judge would never tolerate what's been happening here. But for some reason, they're willing to make these cases, or make these arguments rather, in these cases across the state courts, and they've been able to get away with it now for roughly 2 years.
So going back to Tampa, Hillsborough County, Judge Stevens. Now, Stevens and Lopane, these are the only two judges that you've attempted to have removed or disqualified from the cases. You're not running around just arbitrarily having judges removed, right?
And just to clarify, every one of these courts have ruled against us, albeit wrong, and haven't followed the law, but we haven't tried to recuse them all. This is specific just to these two judges. And frankly, since I've been practicing, I've never experienced anything remotely close to what has been happening.
Yeah, and we're going to get into that. I mean, you've been threatened, you've been badgered, you've gone to the hospital. And we're going to talk about this here in another sworn affidavit from your client. I do not feel comfortable having Judge Stevens preside over my cases, as he has exhibited repeated instances of bias, partiality, even hostility toward our attorney, toward you.
Correct.
How?
Making, and again, the transcripts speak for themselves, but just making these kind of nebulous threats, like if you continue to go down this path, I think you know what's going to happen. Frankly, I'm telling the truth.
The path of truth.
I mean, it's amazing to me.
It'll get you in trouble.
Right.
Believe me, as the host of Patriotically Correct, I'm fully aware of that. I tell the truth, that's hate speech.
Right.
There's over 16 years of work that has gone into these inventions, research and software development. Your livelihoods, reputations, and well-being are on the line, and you're up against a multi-billion-dollar corporation that we believe are willing to go to great lengths to stop us from advancing our case, because we believe if a court would call balls and strikes, in other words, be objective, not try to make up the rules, well, this is a ball here, that's a strike there, but not today, right? Just call balls and strikes as our justice system requires. We believe that we will likely prevail on our claims, which could viably lead to bankruptcy-level event. A bankruptcy-level event?
Yeah, that's what, again...
Billion-dollar companies.
Exactly. I mean, these patents and our license are worth a fortune. And, these are multi-billion-dollar companies, ones you see, on the New York Stock Exchange. I mean, these are your airlines, your hotels, all of them. And if they use points or transfer them across program boundaries, they're infringing. And,
And they all have, allegedly.
Yes.
With stakes so high, there's no room for a judge's partiality being questioned.
And going back to the one point about like people's livelihoods and reputations are at stake. I mean, I'm here on your show, and I mean, this is not, an attorney doesn't want to come out here, this isn't pleasant. I mean, I don't want to have to come out here and talk about how, hey, in 7 different cities, look at what's happening in these courts.
Well, and I'm glad that you bring that up. I mean, so you're not here for your 15 minutes of fame.
No.
You're here to go to your last resort is the court of public opinion, because every other court has shot this thing down. They have not given you your day in court. You haven't even been allowed to take a deposition, as you've previously stated. So, devil's advocate, is it just a crappy case?
We don't know yet, because they won't even allow us to get to the merits of the case. It has been 2 years, and the state courts have not even determined whether or not they have the power to hear it. So and I keep saying this, if we lose, fine. Don't put rocks in your gloves. I mean, let's go in on equal footing and let the chips fall where they may, but we can't get a day in court. So if it's a crappy case, let's get to the merits of the patents. Let's get to the license. Let's get to their knowledge and what they know or what they didn't know, or have them explain in a deposition. Why aren't they warning their customers that they can be sued? But we don't even get to the merits of that, because they are stalling us, because quite frankly, I believe, and I think the evidence would show, that fraud has been perpetuated upon the courts, and that they don't know what to do. Because if I have the opportunity to take the deposition of some of these franchisees, I think that's all going to come out.
Well, not only has fraud been perpetuated upon the court by lying defense counsel, which is clear here by the evidence that you've brought, not by your own words, but fraud is being perpetuated by the court and subverting your efforts to have a day in court.
Well, yeah, and again, like I said before, I have to be careful with the words that I choose, but suffice to say, fair enough. But, it's one of those things where, the courts know the law. That's why they're there. They're there to interpret it, to make sure it's facilitated within the rules.
We hope.
Exactly. And at the end of the day, I would be very shocked if any attorney has ever had this experience where they've been in litigation or in suit for more than now 3 years and has never been able to take a deposition, never been able to get discovery, none of that. And then the question becomes why?
I mean, you're an attorney, you put the case together. Your client has practiced patent law for decades, right? And is very well versed here. You guys are both qualified individuals, albeit you're young and you're a sole practitioner. That's neither here nor there. Do you feel confident that if you had your day in court that this is a winning case?
Absolutely. And not only that, I'll tell you, the other members of the company are also lawyers. We have over, like the affidavit says, we have over 60 years of law experience, and we've never heard of this happening. I pitched this case to multiple other law firms, and they don't even believe it. Other members of the bar don't find this hard to believe that this is happening. And I'm like, look, here's all the transcripts, here are the orders. And it's shocking to them.
Regarding Judge Stevens, there was a news story from 9 years ago that I aforementioned. As further outlined below, Judge Stevens has manufactured scenarios and conjured law that does not exist to help the defense numerous times that are contrary to the most fundamental tenets of civil procedure. How so?
Well, remember I said before that in order to raise failure to state a cause of action, that has to be raised by the defense, not a judge. And then he went on to say something to the effect of, well, you're allowed to have discovery discovery meaning production requests or interrogatories. Yeah. You can have those discovery requests if it can help formulate your complaint. Well, no, the complaint has to stay by itself, and he knows this. He's a very smart judge, actually, and he knows this stuff, but he is literally making things up in law that doesn't exist. And again, the law speaks for itself.
I will tell you, most criminals are very smart.
No.
And most career criminals are very smart. We believe Judge Stevens has tried to convince our counsel, you, Mr. Ferguson, to agree to say things that are contrary to your client's interests.
Yeah.
What does that mean?
So in different occasions, so remember I told you that once he raised this issue of sua sponte, saying you failed to state a cause of action.
On his own.
On his own, correct. You can't go back from that because he's entered the order, it's done. So he kept saying, well, why don't you go back and rebrief this? And I said, Your Honor, we don't want to. And multiple times in multiple hearings, he'd say, well, I'm giving you the opportunity, why don't you take it? I was like, Your Honor, we don't want to. We filed an amended complaint. Well, I'm offering you again, you're not gonna want to do it. And then at one point, he actually entered an order that says, I am ordering you to file an elective briefing. And effectively, in the way in which I interpreted that in my client as well, is he was literally trying to trick us into briefing the issue so that we could go back so he could fix his mistake with
This is optional, but I'm ordering that you do it if you so choose.
There you go. And then got mad at me for not taking this option.
And mad is an understatement. According to the sworn affidavit, once again, when our chosen lawyer does not feel comfortable setting hearings because of what has taken place and the perceived threats made by Judge Stevens, that's a very egregious, that's a very bold thing to say in a sworn affidavit, that a judge has been threatening counsel. That if he did is a very real issue problem. And after reading the October 28th, 2019 transcript, we believe his sentiment is justified. Here it goes. Listen to this now. Listen to this. Judge Stevens has made several jeering comments toward our counsel, you, that were completely uncalled for and out of line. And in fact, the court's coercion and intimidation tactics on October 28th, 2019 were so egregious, this triggered or certainly contributed to our counsel requiring emergency medical care.
Yeah, I ended up going to the hospital after that one.
You did?
Yeah. It's been rough. Just between the stress and then having, this isn't isolated. This is going on, been going on for years. And when your license seems to be threatened, or they're like, hey, we're going to send you to the bar, or if you continue to go down this path, and I'm sitting there going, well, what path? Am I not supposed to advocate about my client? Am I not supposed to say, hey, Judge, we're supposed to get discovery. Am I allowed to push that? And then I'm being told that if I continue to go down this path, you mean doing my job? That I'm gonna, and again, they're very veiled, nebulous threats is how I perceive them. And that, it really was concerning for me, quite frankly. I worked my tail off to get to where I am. I wanted to be a lawyer, like I said, since I was in 5th grade, and now I'm having some judge tell me, and frankly gaslight me, saying that what I'm saying isn't the law, that I'm lying, which I wasn't, and I'm going to be punished for, again, doing my job and frankly doing it well.
The anomalous happenings and rulings are not isolated events. The affidavit says they are systemic.
I mean, this has been going on, especially with this judge, for a very long time. Every hearing, it was always something new. It was always finding or manufacturing law in order to try to justify why they won't give us discovery, why we're not going to have. And in fact, like I said, he's in the complex business litigation unit. So what that means is there are certain rules, like we have to follow this schedule. We haven't had the schedule. It's required by statute and law. I believe it's within 90 days or 60 days to have this plan laid out. Yeah. Never happens in our case.
And I mean, going back and forth, just jumping around here, and I know that this doesn't need to happen chronologically, but when you bring us something like this, obviously we do some research as well. And going back to Judge Lopine, a quick Google search will reveal his connections, his corruption. His grandfather was known as what? The Kingmaker?
Yeah, his grandfather was a very influential person in Broward County, apparently, and was very well connected in the judicial arena.
Well, as they say, the apple doesn't fall too far from the tree. We're going to get into some more stuff here. I mean, we're talking about actual spousal relationships that have affected, or in your opinion, may have had something to do with the way that these cases were ruled on.
Absolutely.
Let's get into that.
Sure. So when Judge Stevens ruled, remember, going back to, again, the issue was subject matter jurisdiction and authority, there was, this fair to state a cause of action. So we're going to jump up to, or over to rather, Pinellas County. So St. Pete, correct. Again, the more egregious stuff happened in Broward County and in Hillsborough. And in Pinellas, I found it interesting is there was this whole issue about sua sponte, raising fair to state a cause of action and subject matter jurisdiction. So if you look at the order, you can see that the judge just wrote the motion to dismiss because he didn't want to write the full title. At least I believe he didn't want to write the full title for failure to state. He didn't want to write the full title that said motion to dismiss for lack of subject matter jurisdiction. He just wrote motion to dismiss ... because I believe that they were in communication and said, hey, look, there's an issue here with...
Who's they? Was in communication with who?
I think it would seem to make sense that based on the transcripts that the judge in Pinellas knew Judge Stevens. I kind of got that impression, which is why after Judge Stevens ruled, he didn't want to write ruling on defendant's motion to dismiss for lack, because they titled their motion for lack of subject matter jurisdiction. So, that was interesting, and those cases have all been laying dormant. But going back to Jacksonville, now interestingly in Jacksonville, after that hearing when I was like, the judge got it, that's the same, that was when the defense counsel said, how much money you got in your bank, because you're going to have to be able to afford this. Well, after having a hearing on subject matter jurisdiction, the judge sua sponte entered on his own, fair to state a cause of action. And I said, Judge, you can't do this. This wasn't briefed. He then sua sponte on his own undid his order and then re-entered an order that said for lack of subject matter jurisdiction. Now, if you remember the map, there was Jacksonville and Gainesville is kind of in the same in the same area. Yeah. In Gainesville, again, it wasn't anything too crazy that happened there. All the cases were transferred to the courts, to the judge there. She found lack of subject matter jurisdiction, but didn't apply the law correctly either. So all of these cases in Jacksonville and in Gainesville went to the First District Court of Appeals. That's right up there in Tallahassee, right?
Yep. So everything, depending on the county or city that it's in, it's assigned a specific appeal district.
Yeah.
Yep. So,
for the reason, correct.
Yep. So 4 would have been Broward, for example.
You got it.
And that's when he said, take it to the 4th.
And I did. That's right.
Yep.
And so likewise, what we did here, and this was the first time we did it. So Brian and I, Brian's actually a phenomenal chess player. He's a brilliant strategist and game theory guy, really. Never litigated a case before, but we would talk about how we have to actively, we started to realize very early on that the courts were doing something strange, and we're trying to
nefarious,
to subvert our efforts. So we had to try to always think 2 or 3 steps ahead. I mean, the whole idea of 3D chess for real is what we were doing. So we would try to jump them and say, okay, you know what, as opposed to amend this, Your Honor, just make it final. And you look at defense counsel and they would freak out, like, why do you want to make it final? I'm like, I'm wanting you to grant, Judge, please grant their motion and make it final. And I'll tell you that in the history of litigation, you'd be very far-fetched to find many cases where a plaintiff's attorney is saying, grant defense's motion and make it final. And then to have it even more rare is when the defense counsel goes, no, don't make it final. Like, why would they want to make it final? Because they know what they're doing is wrong. So what we did is we filed a petition. It's called a petition for mandamus, like I said before. It deals with the authority. It's what happens is when you say, I want to challenge the lower court's correction or whether or not they were correct that the trial court possessed the authority to hear the case.
Okay.
So I filed that and it went to the First District Court of Appeal. Now, within a few days, I got an order back, and this was the first one, and this was a huge win for us, we thought. It said, within 30 days, tell us, it says, respondent, the defense, tell us why this petition should not be granted. So the burden shifted at that point. So it's like, we've read his petition, we agree with him, tell us why it shouldn't be granted.
We all know how elections work. These judges are elected. It's not just you that has had problems with these people. As we already talked about Judge Stevens, a story from 9 years ago where he's just arbitrarily changing the rules, making up laws, it seems, in family court. And now he's presiding over your case. Let's talk more about Lopane. Just a quick Google search here. We talk about elections, right? Money funneling, PACs, donors, big donors, people with motivations to have judges in certain places. This guy, I jokingly referred to him as a mob boss or had mafia ties, is what it sounded like, but it's not really far stretched. Look at this article. This is talking about the removal of Lopane, whereas we saw that people were trying to remove Stevens 9 years ago, and he's still here. Here's an article regarding the removal of Lopane. The late condominium boss, Amadeo Trincitella, they refer to him as Trinchy. This is Lopane's grandfather, who, according to this article, was so politically powerful that presidents and governors regularly called him and stopped by Century Village of Deerfield Beach to see him. Politicians stopping by to see a judge, just checking on him, right? I mean, does that seem weird to you?
Suspect at best.
Yet the fame, clout, and thousands of voters in his pocket didn't get him what he really wanted. He wanted to see his grandson, Nick Lopane, become a judge. Now the story continues. Not that Trinchy didn't try to get Lopane elected. So what does that mean? He tried to get him elected. But even this seemingly all-powerful Democratic leader couldn't get voters to accept his grandson. Yet here he is. I mean, what do you make of all this?
Yeah, I mean, on one hand, it's kind of sad, you feel bad for him, but on the other hand, it's like, why are you so unelectable? What is it that you're doing that where people are so adamant about making sure that you aren't in a seat of power?
Not even a slumlord, a mob boss, your grandfather, who's connected to presidents and high-ranking politicians, could force you down the throat of the electorate. Now, we've talked about Hillsborough, we've talked about Broward, we've talked about the 4th, we've talked about the 1st. This goes into the 11th as well, and then into federal, where even more egregious and obvious collusion at best, corruption more than likely, is taking place. Take us there.
Yeah, so kind of putting the state cases in a box for a bit. What happened was after we filed our test case, we talked about that earlier, Reed Smith and Choice Hotels sued us in federal court, and then we became a defendant. Now, long story short on that gets a little bit more technical, but suffice to say, we counterclaimed, and the Judge Bloom, threw out our case and said that part of the reason she threw them out is because we're ultimately going to have to prove the patents are valid. Well, patent law says very clear, if you get an issued patent, it is presumed valid. So on its face, that can't be correct. So we appealed to the 11th Circuit Court of Appeals. And so for your audience and listeners to know, similar to how we had it in Florida, where if you filed in Jacksonville, northern Florida, it went to the First District Court of Appeal, and from there it can only go to the Supreme Court. Well, likewise, if it's filed in a federal court in the Southern District of Florida, which is where this was, it would then get appealed to Atlanta, Georgia in the 11th, and the 11th Circuit Court of Appeals is where all federal appeals go that are in Georgia, Alabama, and Florida. It's all regional. My friend Lynn
Wood is very familiar with that court.
Yes, Lynn Wood is very familiar. I'm confident he is with the 11th Circuit. So then, and that's where cases are presumably supposed to end, because if you want to appeal after that, that goes to the U.S. Supreme Court. So these are your cream of the crop, smartest legal minds in the country. They know what they're doing. They're very, very smart. They understand what's going on. So when we filed our initial notice of appeal and our brief to the 11th Circuit, the 11th Circuit requires you to submit a physical hard copy. So, okay. So we digitally filed it and I mailed it, and it wasn't compliant for some reason or another. Fine. They said send new copies because you have to have like colors and binding and whatever, it wasn't compliant. So I said, all right, we're going to send it. Well, what was interesting is after we did it all correctly, bound it and mailed it. This is my first time in court. This is my first time at the 11th Circuit Court of Appeals. Like, this is an honor to me. Like I am still. It was an honor and a privilege. I was excited to be able to say, hey, I'm in front of the 11th Circuit. How cool is this? Like,
right. Yeah.
And it's an accomplishment, and I really revere these people. That's what's so sad about this, quite frankly, is like I look up to these people. I mean that.
Yeah.
And I was excited about it, and I briefed the case. I spent so much time on it, and I mailed my briefs. And at the time, I told you before, the only help I was having was law students. So I was like, hey, listen, I need you to mail this and do not screw this up.
Right,
you can imagine this guy's like,
yeah.
I'm not gonna screw this up, right? He's a law student, And so I'm like, this is a big deal. And he mails it. I call the next day because I'm so like paranoid, wanted to make sure this thing gets there. And I called and said, hey, did it get there overnight? They said no. And if it's not here by the next day, it's late. I'm like, what do you mean? So I'm yelling at this poor law student. I'm like,
sure.
How did it not get there? He goes, Wayne, I promise. It got there. It had to have gotten there. I mailed it. I promise. I said, well, you better find the tracking number, what have you.
Yeah.
He pulls it and he gives it to me, and I said, okay, who is this? He said, well, it was signed by a person named B. Greer.
Okay.
So I said, okay, well, that's great. It says it left Fort Lauderdale and it went to 11th Circuit, and it was signed there. Wonderful. So I called the 11th Circuit, and I also had the law student do it as well because I wanted to have two people verify this in case it was ever in question, right?
Yeah.
So I called. And I said, hey, I have something here that says my briefs arrived. And the woman on the phone says, well, there's only 3 people who can sign for briefs, and this B. Greer person isn't one of them. So what happens is at a certain time, I suspect that a FedEx or whoever, they all deliver the briefs, and there's only 3 people there that can sign for them and say, okay, these belong here. And that makes sense because they want to make sure they're one, timely and not late, but they get to the right place.
Right.
So they said that this B. Greer person, not only were they not a person who could sign for the briefs, but they didn't even work there. So my briefs were somehow intercepted. They didn't make there, but they were signed for at the 11th Circuit. And I don't know how that I don't know what could have happened.
Do you know who B. Greer is?
No idea.
Do they know who B. Greer
No,
is?
they had no idea.
Doesn't even work there?
No.
Never heard of him?
Nope. And I even called FedEx, and they're like, we're so sorry, we don't know how this happened. But at the end of the day, somebody signed
At
B.
the 11th
Greer
Circuit, it was delivered to the appropriate place.
and signed board by somebody.
Somebody stole your briefs. I mean,
That's the only, yeah, I think so. That's the only thing I can explain.
so somebody didn't want your well-prepared briefs that you took very seriously. I can tell that you're genuinely,
Yeah.
you revere this court. I mean, this is an honor for you.
It really was.
As a young sole practitioner, this is an exciting opportunity for you. This is like a rookie going to the World Series.
Exactly.
Okay? So you take all this time, you cross every T, you dot every I, you make sure that your law student does, yes, this has to get there. Everything is perfect. Your well-prepared briefs that your opposition, that these defense attorneys know is going to be well-prepared.
Right, and that's the thing, right? It's because it had to be digitally filed before the hard copies went. So I think, personally, what I think happened is somebody or they saw what I wrote and went, oh shit, like, he's got this nailed. I mean, frankly, because I know I'm right on the law. Frankly, we couldn't be wrong because it's so black letter. So as long as our briefs got there, and this is our opinion, or in my opinion rather, I don't know this for certain, but as long as our briefs got there, I didn't know how we could lose. Even after their response to our brief, how could we lose? The law, it's very black letter law on this. So that was the beginning of what was soon to be a series of very questionable and then, frankly, disturbing things that happened at the 11th Circuit, which is one of the most prestigious courts in the United States, quite frankly.
Now, if you're lying if you're just making this up, you could be subject to some serious penalties.
Sure. I mean, I'm not, look, I'm having to, I have the facts. I'm presenting the facts, and I have to try to, thread the story, because I'm trying to make sense of nonsense right now. Like, how does my briefs not show up? Who is a B. Greer person? Who wants to, if you're going to steal something from FedEx, take something out of an Amazon box. Who wants to steal briefs?
Why is an objective number all of a sudden no longer objective?
Right.
Why is a judge that a case is supposed to be assigned to not assigned to that case? Why was it supposed to go to the chief judge, but it never happened? Why is Lopain refusing to recuse himself? Why would Stevens refuse to? Why does
Stevens want the case?
Why are they fighting to keep the case? Why should they care? Why would they want their docket size to increase? Why would they want a heavier workload? Why does this case make a difference to Stevens or to Lopain?
And this goes back to, in your opening, really nailed it. It's the widespread something's happening. I mean, what are the odds that 7 judges in state court all don't follow the same law? What are the odds that 4 out of 5 of Florida's appellate courts not follow the law? What are the odds that I present demonstrable evidence that shows that an attorney of the Florida bar is misstating what they are giving to judges as orders to sign to throw out our cases, and they ignore it?
Especially when you're talking about a case that has close to $100 billion of liability attached to it.
Of potential implications, exactly. And I mean, and that's, and like, okay, well, if it was one instance or just 2 instances, but no, this is systemic of people not following the law. And then, okay, well, maybe it's just Florida. Well, no, I'm in the 11th Circuit Court of Appeal.
So your briefs are missing. I'm going to say intercepted and stolen, nefariously, egregiously, and on purpose.
Sure.
Let's just say that happened. Okay, so now you're saying that this was just the first of many inconsistent or anomalous
events. Correct. Now, mind you, it was my first time in the 11th Circuit. So for all I know, I don't know what I don't know, and I'm willing to accept that. I'll say that right now. I don't mind not knowing, and I don't mind telling you I don't know. So I figured, okay, maybe this can happen, whatever. So I ended up printing them for the 3rd time, sending them, then they get the hard copies. They ultimately file a response, and we reply, and then what happens is sometimes you can go to something where it's an appellate mandatory mediation. Okay. Now, mandatory mediation means exactly that. You have to go. So now, if you look at our filings in federal court, and frankly, I'm providing them to you, but the case was against the franchisor, Choice Hotels, and one of the franchisees, both.
Okay.
So both parties were required to go to mediation.
That's what mandatory means.
You think, right?
Yeah.
So
I remember in football, you have a mandatory meeting. If you don't show up, guess what? Your playing time's probably going to be non-existent.
Well, and that's exactly what should happen here. If you look I was looking up case law, and you'll see why in a second, that if you don't show up, you're getting sanctioned. Either the attorneys for not telling them to be there, or the client,
or even the whole firm.
Right, because I was frankly, I was terrified of the 11th Circuit. I wanted to make sure everything was compliant, because I respect the court, frankly. I revere it so much that I'm going to be overly cautious, because I want to make sure I'm doing things right and compliant. And so,
And in your affidavits, in your briefs, in everything that I've read, it seems like you're almost overly polite, trying not to overstep your bounds.
Correct. And then making things worse, I'm having to talk about uncomfortable subject or topics like, well, there seems to be some collusion, but I don't want to say that. That's not comfortable to say.
Right.
So, but at a certain point, and ultimately end up telling the courts is, look, this isn't comfortable, but I don't know how else to say this. Something's happening, and it's not good. This is not a good look. I mean, that's something that keeps coming to my mind. It's like, this doesn't look good when multi-billion-dollar companies are somehow taking advantage of a small business, or these huge billion-dollar firms are taking advantage of a small practitioner and trying to overtly and just say,
intimidate,
and try to say, hey, we're just going to drown them because they can't afford it.
We're going to exhaust you.
That's not what this is supposed to be about. So we show up to mandatory mediation.
It's the death of 1,000 pricks.
Right.
Yeah.
Well, and I tell you, and that's what ultimately, So as you talked about the affiant and the inventor Brian, we spent, I think it was like 4 or 5 hours preparing a confidential mediation or a settlement offer for the franchisee. Mm-hmm. Okay, and I can't obviously talk about what the contents of it is, but the idea was that we've got a hell of an offer for these guys, to where it's like an offer they wouldn't want to refuse. It gets them out of litigation. I feel comfortable saying that, and there's no reason they wouldn't want to accept it. But here's the thing: who showed up to that mediation? Choice, but not the franchisee. So, in other words, we weren't able to present our offer to the franchisee, who is one of the defendants or one of the appellants at the 11th Circuit. So we had an attorney who you'll come to find out actually wasn't even representing Choice formally show up with only the franchisor, Choice, and the other party didn't show up. So during mediation, I'm like, well, we have an offer prepared for the franchisee. Where are they? Well, they're not here. We're here. We're gonna take everything. Well, think about the conflict of interest there. Of course, the franchisor isn't going to want to allow their franchisees to settle because their interests are different. Because if the franchisee settles with us,
now you sweep.
Boom, you got it.
So every franchise
they have every
then
incentive
becomes complicit.
They want to settle. They have every reason to come to us. We're willing to offer them a hell of a deal at first to come settle with us, but they're not taking these offers. Why? I'm wondering, frankly, I'm wondering whether or not they're ever being conveyed. So we're supposed to be at mandatory mediation. Choice Hotels shows up with Reed Smith and the other party doesn't. So, of course, I move for sanctions. I bring this to the 11th Circuit's attention, ignored.
Reed Smith shuts, these people are stepping in the way. Judges are openly stepping in the way. Look, a different judge altogether was supposed to have this. And another judge literally intercepted the football or caused a fumble, taking the ball away and saying, no, this is my football now. On purpose, that's an intentional act. And now you have franchisors and in the 11th Circuit, the most prestigious, arguably, in the country.
They're definitely up there. And these guys are smart. And like you said, you don't have to be a lawyer to understand this. What does mandatory sound like? You got to be there. So if you're not, you get sanctioned, or why not? And like we said, can we please have another mediation? Give us another one, because I guarantee you they'd accept this offer. And sure enough, they didn't. So
they didn't accept it, or they didn't agree to another mediation.
We didn't. I moved for sanctions, and they just said denied. We're not letting it happen. Okay, so it doesn't stop there.
So now, what if you hadn't have showed up? I can only speculate that you would have been sanctioned.
I would hope. Frankly, I hope I would want to be sanctioned. I mean this. Like, people are like, oh, this judge is strict. I like strict judges. I like rules. I'm a rule follower. If it says do this in this amount of days, you do it. If they say to be there, you do it. With very few exceptions, or doing something illegal. No, you do what a judge tells you.
Yeah.
I don't care if you're a 60-year-old seasoned attorney or you're fresh out of law school. You do what the judge says.
And I'm not taking your word for it, folks. I have looked at every single document that Mr. Ferguson has provided. Every document that you've provided substantiates the things that he's saying here on this program. This is systemic, deep-seated, deep-rooted, widespread corruption. And you don't want to say it. I will. There is somebody standing in the way. The truth is here. What's going to be done with it? What's next?
That's the heart of it. It's like, like I told you, you don't have to believe anything that I say. I'm going to provide every transcript. I'm going to provide every filing that I have. I'm going to send everything and have it laid out. So
I've seen these transcripts where you question the judge. You state fact, and the judge literally says to you, step aside.
Right, yeah.
Because the judge can't answer your argument, can't answer your question without lying again. And these people have lied about lying, and it's on the record. How about the way that you were served? How about you guys could go look this case up just like any public case, right? I should easily be able to go look this case up, but I have bad news for you. Why?
Yeah, so this is what's wild. So, this stuff's all supposed to be open public record. And so in some of the counties like Hillsborough, you go to Tampa where Judge Stevens is, you go there and look up our case, you can't get it, you can't access it. So they actually have had stories about these things called like hidden dockets, where they won't allow you to see the documents that are filed in our cases. They don't want people to see what's being filed in our cases. Again, don't believe what I say. You can go onto the Hillsborough County HOVER website and you can type in these case numbers. You won't be able to pull up the orders that are being written or the complaints that are being filed. And I have reason to believe that even the clerks, they've mislabeled some of the titles of the...
Intentionally.
Yes, and have rejected. I can't tell you how many times I've e-filed documents and they're arbitrarily rejected for reasons that they'll tell me one reason it's been rejected, and then all of a sudden they'll give me another one that's contrary to it, and then all of a sudden my documents won't show up. So I'm always having to check my own SIX because I'm a sole practitioner.
What about appeals? You have you've gone to appeal, and you were telling me, I don't remember if it was on the phone or if it was before we started our interview here, but you were telling me about when an order is signed, okay? Oh, yeah. And we were talking about, now I've been to court many times, okay? You get through a case, an order is signed. You're looking for a reinstatement and discharge of a bail bond in the criminal world. You submit a petition explaining to the court why you think that your case should be heard, and here's a proposed order even that you can give to them. Of course, check the box, sign the judge's name, or an alternative, a judge can then write something different, but you are returned a written order. Usually you're e-served or served by certified mail or by in-person service. That's how orders get done. Not in your case.
No. Typically what happens is in Florida there's an e-portal. So every time you receive an order from a court, it's going to come through the portal, as it should be.
Yes.
And for Judge Lopain, and this going back to the cases in Broward County.
It's secure, it's certified, and they know that you've received it.
Exactly.
There's no way to dispute who has seen it because you select who's going to be served.
Absolutely.
What parties are privy to this information, whether it's public, whether it's private, whether it's all those things.
You got it. And what I find fascinating, I mean, again, there's a certain point, well, hey, was it an inadvertent error or like coincidence? I mean, when you throw out someone's lawsuit, that's a big deal. That's like, hey, you're done. You're no longer in court. Every order that I received from Judge Lopain in Broward County that threw out, remember we have 10 cases, either 7 or 8 of which that we've received thus far, every one of them have had problems. The first time I tried to receive the very first dismissal order that I was telling you about that we ended up petitioning to the 4th DCA, I got a call from his judicial assistant and said, we're going to have a hearing in a couple of weeks, and we're going to have an oral order to where you show up and we're going to announce what we're going to do then. And I said, well, is there going to be a written one? I'm thinking to myself, I've never heard of such a thing.
I haven't ever heard of that either.
Yeah, and by this time we know that there's something going on. And again, if I'm making this up, I should be sanctioned. You don't lie. Like, I'm an officer of the court, okay? So I have an obligation to the bar, to the judiciary, to justice, to tell, this is what's happened. And frankly, motives, I can't read minds, but I can tell you that I was told to show up in a court day on a Friday, and he would announce what it is then. And then immediately my thing was, well, I don't want to just do this over the phone. I want to be in person, and I want a court reporter there.
And the reason?
Because I didn't trust anything that's going on, to be frank, at this point.
I can't imagine why.
I mean, right. So sure enough, and I said, well, is there going to be a...
Wait a minute, you don't trust Trinchy's grandson?
Yeah, right,
hey?
right, yeah.
Old Trinchy, eh?
Hey,
Come on.
At this point, it's just...
Get out of here.
It's gotten absurd. And I don't want to be that guy. I'll be honest. I don't want to have to constantly question the judiciary, because it's not how I was raised. It's, trust the police, trust the judges. These are the good guys.
We were always that way.
You want to be that. You want to believe that. So this has been deflating. And I'll tell you, and just a brief aside, it's like the guys who are working for me, again, I'm a sole practitioner working my tail off 13, 14 hours a day, 7 days a week for a solid 2 years, because I have to make up for the 14 lawyers and assistants that they have. These guys are in law school, and they're sitting there going, this is sad. Like, I want to become a lawyer, and I'm watching the system just fail. I mean, I'm talking just, we're not going to follow the law. It's like, what's the point? It really does impact.
It's disheartening.
That's the word for it. It's disheartening that this has happened. And so, I show up and, I said, well, I'm going to have a court reporter there. Great. Well, the day before we're supposed to have this oral order, he writes a written one. So it doesn't stop there. So then that was by far.
Just stop for a second. The day before this weird, first time ever in your history, oral order is going to happen. Now, you've questioned this. And you've said, no, I want to have a court reporter there. I want a written order, because you're going to have something to appeal.
Yeah, I knew he was going to have to appeal. The guy's never going to rule in our favor.
Correct.
No one has. So
and it's been proven that he's not going to do that.
So I knew it was coming. So anyway, the day before, we get an order through the e-portal, which is even though we were joking, we said, well, even though we lost, I was like, at least it was a clean order, because everything else has been sua sponte this or something that wasn't argued, but at least it was on the subject matter. We're like, all right, great. So that was the only one that we received that was somewhat normal, meaning it was through the e-portal. So remember, we have 9 cases pending in Broward County or in Fort Lauderdale, right? They're all with the Judge LePayne. The next series of orders that we received, and here's the thing, we're entitled to have a hearing, or at least have each case heard on the merits. And despite having, being wrong, so to speak, I'm going to call that's what it is, okay? I kept saying, I got to do the right thing. And that's not me being holier than thou. It's me saying, Wayne, no matter what, and I think I told you this, I was like, there's something about truth that's like heat, it rises. I'm like, just keep, you're not, head down, grind it out, and keep doing the right thing. Eventually, this is going to surface.
I don't believe you're being disingenuous.
No, I'm fallible like the rest of us, but I do try to do it right, if that makes sense. And so, I just keep going, and all of a sudden, so I said, as opposed to having a whole bunch of hearings, Your Honor, I said, let's just, if you're going to rule the same way, I understand why. Let's just not consolidate, but just enter the same order in all the cases, because there's no reason to waste this court's time. If you didn't buy my first argument, you're not going to buy my second one. Fine, I'll appeal it. So this is what was so bizarre is all of a sudden I was expecting to get these orders in, and then I didn't. Now remember, every time I've received an order from every other court, not only in our cases, but those in the past, but even in the point conversion cases, they always come through the e-portal. Well, an order was supposed to be entered in these other 9 cases or 7 cases, and I didn't receive it. So then all of a sudden I went to a hearing and I said, Judge, I thought you were going to be entering an order. I never received it. And he goes, well, we got them. But somehow or another, defense counsel goes, Judge, no, it was entered. We checked the docket. So how did the defense counsel know that it was entered, but I didn't? So I thought that was a little odd, and I said, well, Judge, are we going to receive something? I mean, literally, on the record, you can see it. I said, Judge, are we going to receive something through the portal? Like, how did I know that this would be entered? Well, I ended up checking on the docket, and it was entered, but I didn't receive a copy of it. Now, again, I'm trying to piece facts together to kind of say what I think's been happening, but ultimately, imagine this. I received a package, like a big vanilla envelope, okay, filled with orders from Schutz and Bowen, meaning the defense firm.
From the defense firm.
I received, so hear me out, I received the orders throwing out our cases from the defense firm. I never received anything through the e-portal. Through the e-portal, you got it. So I'm like, how does that
You weren't
happen?
served by the court. You were served by the defense attorneys.
Yeah, and I'm like,
who you are fighting against.
Correct.
On behalf of your client.
And I, again, to this day, I have no idea how that happened, but because I was like, this is so bizarre. I took a picture of the box, of the package it came in, because I have all this documented because I was so confident at this point that so much, I call it just shadow activity, something's going on that, like, how did I receive orders? Everything comes to the e-portal except these cases that are throwing it out. So then I said, at another hearing, you can see this for yourself. I said, Judge, how is this happening? And by the way, the orders that opposing counsel is representing that they are, those aren't them. Like, he literally said, Judge, here's the order that we agreed upon. It wasn't. I then called him out, and he goes, oh, Judge, that was an accident. That order was supposed to emulate this one, except he lied about lying.
Because that one isn't it either.
It wasn't exactly, right?
And this isn't just happening in Broward County under LePayne. This is happening in Miami as well, or something at least similar.
Yeah. So in Miami, again, same motion, same move to dismiss for lack of subject matter jurisdiction and authority. The judge there got a call from the JA, just like the judicial assistant, the JA, got a call just like I did from the judicial assistant from Judge LePayne, who said that Judge Guzman is his name, said that he likes to talk about what he's going to rule before he does, and they're going to have a conference.
But this is like unheard of. I mean, judges, why do they want to talk about what they're going to order? I've never heard of this in my life ever.
I'm an attorney and I haven't either, so this is all new to me as well.
I mean, a judge, a district court judge, an appellate court judge, they just order what they order. They make up their mind and they write an order, and that's it.
Not in our cases, though. You got it. So
your cases specifically.
I've never, again, this has never happened to me anywhere else.
You office with other attorneys.
Absolutely.
Attorneys that have a lot of experience, I'm assuming some that have been in the business for a very long time. Have you spoken to them about this?
I have, and that's been what's, I've had to kind of check my own six, so to speak. I mean, I got to make sure that, I'm doing things properly and making sure that maybe I'm looking at this wrong. Like, I have to consider the fact that I could be wrong. Yeah. And that'd be very myopic of me to not at least, ask somebody else's opinion. And when I share what is happening in my experiences with other seasoned attorneys, members of the bar who are, in their 60s, very established, prestigious lawyers, they're sitting there telling me, like, Wayne, this is hard to believe. This is if what you're saying is true, you're gonna need to go to like the FBI in order to get redress here. Because think about it, if something's going on that's sinister in state court, or whether that be with the attorneys, well, if the state judges are letting it happen, what are they going to judge them? I mean, they're going to adjudicate their own cases? Like, how am I going to get redress here? So, when bringing this to other attorneys' attention, they're even shocked about what's happening. They find it hard to believe.
And we all trust the FBI.
Yeah.
I'll just make something perfectly clear. When you leave here on your plane tonight, just to make sure here, you're not considering self-harm, and you're totally healthy, right?
Yes, I am. So
you got that.
We're good. Yeah, we're good.
Let's recap, okay? You've been to the first, the second, the third, and the fourth. So let's start in the first, Duval, Alachua. There were anomalies and inconsistencies here.
Right. So before we get to that real quick, let me touch on the third really quick before we get back to the first, the recaps. Because when I was in Miami, remember I was telling you about those oral orders. The judge said we were going to have an oral order, and then they ultimately didn't even happen at all. He ended up just writing a written one. Now here's what happened there. Remember I was telling you before that, again, the first, second, third, fourth all say that a petition for mandamus is the proper way to challenge subject matter jurisdiction. And
whether or not the court has authority.
You got it. So I filed another petition in the 3rd District Court of Appeal. 3rd District says, okay, we'll accept your petition. Defense shuts, you respond. They file a response. Okay, briefed. I file a reply. So it's like a ping pong match, like I said before.
Sure.
Petition, response, they replied. Issue is fully brief, right to be decided. They write a 6-page, I think it's about a 6-page opinion that says all the reasons why they don't believe that they can decide the merits. So think about that. The entire case is ripe to be decided. It's fully briefed. And they said, we're not going to decide it. This should be decided on appeal. So,
what would you be appealing?
The same thing, the same subject matter, the same issues. They just said you need to file an appeal as opposed to filing a petition.
Okay.
If it doesn't make a whole lot of sense, it shouldn't, because again, what they want us to do is to file a notice of appeal, and I will literally be making the exact same arguments that are right before them. Meanwhile, these same district courts of appeal have said, we disfavor piecemeal litigation. The idea is, look, get your case through, get it heard, get in, get out. Justice delayed is justice denied. We've heard that saying. Well,
of course.
Point of Conversions has been denied justice for about 2.5 years now, or more, frankly. And, again, the case was ripe to be decided at the 3rd, and they said, well, we're not going to decide the merits. We want you to appeal and just do it all over again.
And before we get into this recap, I just want to remind everybody, this is over 2 years.
Yeah.
You have not even been allowed to take a deposition, much less get the case heard.
They haven't even answered the complaint. 2 years. This is unheard of. Any practicing attorney will tell you that this is, they've never heard of such a thing.
I hope Governor Ron DeSantis takes a look at this and seriously considers complete judicial reform in Florida.
Something needs to be
You're
looked
cautious.
at. Yeah.
You're cautious, and I understand why. You have a license to protect, you have a bar to look after, things like that. They look after you, you're under their thumb, they regulate you. They don't regulate me, they don't regulate the court of public opinion here. This is corruption. This is stonewalling. Okay, Duval, Alachua.
Yeah, sure. So, kind of recapping where we're at in the state. So we had in Duval, Alachua County, so we had the judge who, in Jacksonville, Duval, sua sponte, took all the cases, consolidated them. He did it on his own accord, put them all in one. He said, I'm going to copy what they did in Tampa. He did a fair to state a cause of action. When I called him out on it, he said, wait a minute, I'm going to undo that. Undid his order exercised jurisdiction to undo his order, to vacate it, only to then enter a new order that says he lacked the authority. I don't know how you can do both. You can't, but
I lack the authority to do this, but I'm going to use my authority to do that.
You got it.
Okay.
As nonsensical as that sounds, that's exactly what happened.
Sure.
So that happened there.
I'm not an attorney, but that seems pretty clear.
Yeah. And Alachua, again, going back to just the law says to follow these factors, didn't happen. Those cases all went to the First District Court of Appeals. First District Court of Appeals, that's in the northern part of Florida.
Correct.
This is the same Court of Appeals that said, tell us why point conversions petitions should not be granted. Remember, we talked about the burden shifting. As soon as they said it shouldn't be granted, I'm thinking, we got this finally. They're finally calling balls and strikes. And then that's when they said, well, tell us why it shouldn't be converted into an appeal and dismissed. And that's why I petitioned the Florida Supreme Court the first time. I said, don't let them do this. And then 7 days later, they discharged the order. They said, no, we take it back, fine. To date, as of today doing this interview, still haven't heard anything from them. That's at the first. The first is also the same court where the appellate attorney, Daniel Nordby, his wife is on the court, that wasn't disclosed right at the beginning that I didn't know of, who's also, I believe, was Charlie Crist's lawyer, the governor of Florida's lawyer at the time as well. Again, that case still hasn't been decided. And again, this is a terse or a cursory overview of what's happened, but these, again, I mean, this has been going on for a while, so there's a lot of other things in these courts that are happening. Yeah,
of
right.
Course.
And so this is just scratching the surface. But suffice to say, yeah, that's what's happened in the first. And then where are we going from there? The first, we're in the
into the second in Pinellas and Hillsborough.
Sure. So in remember in Hillsborough / Tampa. Yeah, Stevens. Yeah, he's a peach. Yeah. He's the one where again. Brilliant guy. He wrote an article in the Florida Bar Journal about subject matter jurisdiction and tries to tell me that subject matter jurisdiction and failure to state a cause of action is one and the same when the Supreme Court and the Florida Supreme Court, U.S. Supreme Court, they all say it's not.
So
he knows it's
when
not.
When he wrote the article and then when he ruled on your case, he was either lying then or lying now.
Yeah, and he tries to justify it, and like when he talks about it in these hearings, and it's,
This is just a question of which time were you lying?
Right, or why are you making exceptions to this case? Because his article's correct. That's the thing. I agree with everything he's saying, and I actually brought his article to our second hearing. I'm like, this is a brilliant guy who wrote this. I'm like, and all of a sudden he changes how he said, well, that was written a long time ago. My opinion is now changed a little bit. Well, that's convenient for our case, of course.
But the law hasn't changed.
No. Well, the standards have, but the as far as the authority and subject matter jurisdiction, no. This goes back to literally
right, specifically the authority.
Old English law, right? I mean,
that has not changed.
No, that's been the same since Old English times. So Judge Stevens, the same guy, berated. That's the one when our affidavit berated me. It's the one that made these like nebulous, veiled threats about if I continue down this path, I hope you know what happens.
What does happen?
I don't. It sounded like to me he was trying to say that I was lying or was going to report me to the bar, to some agency for doing something improper.
Okay, so just in fairness to my listeners, are you lying?
No, I have no reason to lie. In fact, I'm overly cautious not to say anything inappropriate. I'm so overly cautious, quite frankly.
What could happen to you if you lied in this interview?
I don't know, but I do have an obligation and an ethical obligation to respect and uphold the law and the judiciary. But in the similar vein, I have an obligation to rectify things that I see as wrong. And that's just not as a lawyer. I think you'd be the same as a man. When you see something wrong, you speak up. You don't just watch.
I think any alpha male or type A personality male that has been brought up with core values and a sense of integrity, I think one of our faults is we always try to fix things very quickly. Sometimes that's great. Sometimes it gets us into a little bit of trouble when we're trying to fix everything that we can't necessarily fix. It seems that you're in one of these situations right now. You want to fix it, but the cog, you're just a cog. You're just a pawn in this huge unmasking of what appears to be systemic collusion, if not full-blown corruption. Right. Somebody's getting paid. That's my opinion.
Or like you said before, it's either that or somebody doesn't want these patent cases to be heard in Florida for the reasons
that's it. I'm just going to go with my gut. I've been right more times than not with that. Pinellas.
Fair enough. Remember in Pinellas, we talked about how Judge Stevens, there was the issue with, was it for failure to state a cause of action or was it for subject matter jurisdiction? That's when you have the blank order that says, well, I'm granting the defendant's motion because they didn't want to say the word subject matter jurisdiction. And in my belief and opinion, it's because they
know each other.
And they obviously knew that
they're right across the causeway from one another. They probably meet for scotch.
Yeah, you got it. So they, in my opinion, it sounds like they obviously knew that, hey, there's a problem. He realizes that you can't rule on subject matter jurisdiction. They only talked about it didn't talk about fair to state a cause of action, so just keep it blank. So there was that.
We just talked about the third Miami-Dade.
Yep, and then when we went, remember in the second two, I petitioned the Second District Court of Appeal, and remember I tried to move to disqualify Judge Stevens. Again, is it reasonable to believe that everything that you read in that affidavit, that he should have been disqualified?
I mean, you went to the hospital.
If nothing else, but also talking about ex parte communication, meaning we have reason to believe that he was talking to the defense counsel outside of court. That's a case law. It's clear that is a almost a de facto. If you've done this, that is a reason that somebody should have a reasonable belief. As long as it's not fanciful, you should be disqualified. We moved to disqualify him 3 different times.
Why is he fighting it?
That's actually the very, very good question. Why does a judge care? Why does he want to preside over this case so bad? And think about it as from the litigant. This isn't about me, okay? This isn't about the judge. This is about a person trying to get into court to have their case heard. So if that person doesn't,
at every angle.
And that's the thing, right? It's like if a client, if you're wanting to make sure that your case gets heard, and you are that adamant that this judge is biased or doesn't like your case, and somebody is willing to pay me, okay, and I have to write these motions. I mean, they're very lengthy, and if we've tried to move to disqualify them 3 times, let's just say we're wrong. Let's say we are, hypothetically. Why not just say, you know what, fine. They're that uncomfortable. Let's make sure that this person feels like they can get a fair trial. Does that make sense? Yeah. It's like, just err on the abundance of caution, and hey, I'll step aside.
It's not a hyperbolic statement to say that there's motive. I mean, there's motive here. There's a reason why he wants to stay on this case. I'd love to have him on the show to ask him.
That's a good point. It's kind of like with Judge Lopane over in Broward in Fort Lauderdale. It's like, look, clearly something's going on. They handpicked you. In the abundance of caution, just appease, the litigant. He wants to make sure he gets a fair trial. That's reasonable.
That there was a story 9 years ago about Stevens. He was making things up in family law. He was voted a very bad judge. I mean, it was all over the place. We showed that news clip. And then Lopane, I mean, even his mob boss grandfather, who did everything in the world to try to install him, and he wasn't good enough for the voters. He's been in trouble. They're talking removal. There's articles all over the place. These are the judges, the 2 that you're trying to remove. It's no surprise to me. That seems like common sense. You haven't tried to remove judges in all of the other 5 places that you've been at. I mean, this isn't you whining or complaining. This is you just trying to get a day in court.
Exactly. And and really, it's not about me. It's about my client. My client wants to make sure he gets a fair trial. So then when we appealed, Judge Stevens denied his own motion to disqualify. So certainly the Second District Court of Appeal has to review it and say, did my client, Brian, the affidavit that you read, did he provide a reasonable belief that he has, concern that he's not going to get a fair trial? Absolutely. No one reading that could not think that it wasn't legitimate, and yet it was denied for no reason. And you're going to see this every time in these appellate cases. Our opinions are either denied completely or for reasons that don't align with the law or with our facts. And so again, now we're stuck here with we were stuck with Judge Stevens, with a guy who is actively trying to, or at least we believe is actively trying to subvert the litigation in order to, frankly, help the defense for reasons we don't know. But it's systemic, and it's not like it's a one-time thing. This has been happening for literally 2 years now.
So we've got Duval, we've got Alachua, Pinellas, Hillsborough, Miami-Dade, Broward, and Palm Beach. We've got districts 1, 2, 3, and 4.
We've got them all, but exactly. And so where we're left off in state court, and again, this is the tip of the iceberg, so to speak. But the last thing that you had, the first thing that you read rather at the beginning of this segment is kind of where things are left off right now. So with the 4th District Court of Appeal, like I said before, with Broward, we had filed a petition for mandamus within 30 days, and they had said that, well, since we're not accepting your petition for mandamus and you didn't timely appeal, we're not allowing you to hear it. So that's effectively denying us a constitutional right to have access to court. So we actually sued Judge Lopane in federal court. You can look this up. We sued Judge Lopane in federal court, and the federal judge about 2 weeks ago, threw our case out.
Is it possible you sue a guy in court, it pisses him off? I mean, he's a human, right? How dare you? I'm a district court judge. How dare you? You sue me in federal court, you sue the state, you challenge my authority, you're trying to make a mockery of my court by being in here, I don't know, telling the truth, doing your job, litigating on behalf of your client, or at least attempting to. Is it possible he wants to stay on the case for reasons that are more personal?
I can't imagine someone would want to stay on this case after what we've been alleging against them. You would think, at least if I'm sitting in these guys' shoes, I would be like, you know what, this is more of a hassle than it's worth. I'll clear them off my docket, make sure they get a fair trial. That's what should happen, and that's obviously not what is happening. But, so the 4th District Court of Appeal, literally in their own rules, it says in 30 days you get a right to an appeal. We file within 30 days, and they say you're untimely. So, Stu, we have 30 days. I file within 30 days and they say you're late. And I'm like, no, I'm not. It's within 30 days. So now I took that case and brought it to the Florida Supreme Court's attention, and they denied my petition. So the Florida Supreme Court has been made aware that we have sought an appeal. I mean, these are the Florida Rules of Appellate Procedure. These are their rules, okay? Seeking an appeal, seeking to have our case heard in an appellate court within 30 days, and nothing. They denied it.
Why is it your job to go to one court to instruct them to tell another court how to do their job?
It shouldn't be. That's the thing. Is remember, the appellate courts are supposed to oversee the lower courts, or the trial courts rather. So the cases are the buck's supposed to stop with the district courts of appeal. The Florida Supreme Court's only supposed to hear very few and rare cases, and for good reason. But what happens, and this is the question that I keep asking myself, and I struggle with, frankly, well, wait a minute, what happens when these district courts of appeal are not following the law? Who's to keep them in check? And I don't have an answer for you. But I can tell you that I can read a law when it says 30 days, and Stu can count, and if you can count 30 days, and then all of a sudden I'm not allowed to appeal, well, who do I complain to? I've got nowhere else to go.
Well, let's go to the 11th in Georgia again. It seems that somebody can't count. And it seems that somebody doesn't know what timely means. This is really interesting here. Now, take us through what a SIP is.
Sure. So remember I was telling you before about how, when you file in the 11th, we had issues as far as people showing up to mediations and whatnot. And the point of the matter is that every company or every party that has to go have their case heard at the 11th Circuit, because it's an appellate court, it's a federal case, you have to file something called a SIP, or a Certificate of Interested Persons and Parties. Okay. And the idea is that the judges need to know, whether they have a personal interest in the outcome, so that they could say, hey, I can't be a part of this case because I have a personal interest, because they want to be unbiased for good reason. So what happened is after the case was fully briefed, so this has already been slated for oral argument. Mm-hmm. Our case is on oral argument, you can look it up. I got a notice from the court that said that the franchisee, Tropical, right, and I think this is something that I had sent you.
Who did not show up.
Right, this is Tropical, who's the one who didn't show up to mediation. Yeah. They did not fill out their SIP statement, their Certificate of Interested Person. So it said, hey, you got to look, submit one. So I called because I was like, this is taking a while for them to submit something. So when I called the clerk, I said, I understand that Tropical doesn't have one. So I said, well, where's Choice Hotels?
Right, the big one.
Right, the franchisor. They're the billion-dollar company. So yeah. I said, where is their SIP statement? And the clerk said, who's Choice? And
this is unbelievable.
And I said, they're the other party to the case. And they said that they are not a formal party to this case. So again, we have submitted motions, briefs, mandatory mediation, filings, and
Choice showed up to the mandatory mediation.
Right, remember that. So Tropical didn't show to the mediation, and only the representatives from Choice did, but yet the clerk is now telling me after everything's happened that Choice isn't even a formal party to this case.
So you do a motion for clarification.
Yeah, so I'm sitting
Rightfully
here going, look, I don't know what the heck's happened, but something's not right. Something's rotten in Denmark. So I said, all right, let me file a motion trying to be very, again, even keel. I'm not going to file for sanction this, the other. I'm like, just tell me what's going on, court. So I said, move for clarification and tell me who are the official parties to this case, because clearly the clerk's telling me that the main franchisor, isn't a party here.
Yeah.
So who's the parties to the case? Who is the attorneys representing
All reasonable
them?
stuff.
Yeah.
So now, this is where it really gets juicy. Okay, so Edward Mullins, right? This is the attorney of record for Tropical.
Yeah, that's the Reed Smith from Tropical, correct.
Okay, so this is the person that's listed. Now, you're asking for clarification. When asked where the other party, Choice Hotel International Inc.'s, was, the clerk conveyed that she did not seem to believe that Choice was party to the appeal. This leads you to other questions. Eventually then, you have a picture here. What is this?
Right, so this was when I started to figure out, look, according to the docket, and after speaking with the clerk, it appears that Choice isn't a formal party. So you can look at the appeal. This is my notice of appeal that I filed in the Southern District of Florida. Again, there's Tropical, there's Choice. So they were supposed to be a party here. Now, this is what I brought to the 11th Circuit's attention. So while they're supposed to be a party, here's an order that they entered. So you can see Point Conversions is a party. There's another entity here that was in the lower case. But look, there's Tropical, and there's no Choice Hotels isn't a party to this case. So I'm thinking, okay, something's not right here. So then I went back and looked at other filings, and then I realized, so this is the notice of appearance of counsel form.
Yeah. So
anytime you file something in the 11th Circuit of the Court of Appeals, you have to say who you are and who you represent.
Yes. Yeah.
So as you can see here, it says Mullins represents Tropical, not Choice. Now, mind you, Mullins showed up to mandatory mediation
On behalf of Choice.
Right, who
And
he doesn't
Tropical
represent, and Tropical wasn't
Was
even
absent and unrepresented.
So how am I supposed to, or in Point Conversions, how are we supposed to make an offer to a party who isn't there by someone who isn't represented by them either?
But it gets deeper. So now they're lying, they're scrambling, they're actively trying to cover something up here. And all of a sudden we have a new party that appears by the name of Daniel Sachs, another attorney,
right.
who represents stating that he represents Tropical and Choice, right?
Right.
Can you do that?
Well, so this is what I think's happened. So, I mean, the stakes here are high. Let's be real. We've talked about the numbers, right?
Yeah. Billions.
Yeah, and so we have been, we've been litigating this even in appellate court for a while. They've asked for extension after extension after extension. They have to have their briefs. They're due, okay? This is Reed Smith we're talking about, 1,500 attorney firm, making billions of dollars. They know their stuff. They have more than enough resources to do it. They know what they're doing here. So here's what I find interesting. The day the brief was due, their brief was due, at 11:43 p.m. at 12 midnight, it's late.
It's late.
Correct. We all of a sudden get something that says a notice of appearance form filed by Sachs,
Yeah.
who represents Tropical and Choice.
Yeah.
Because remember, the other appearance of counsel form only said Mullins represents Tropical, so no one was ever representing Choice.
Mm-hmm.
So then the question becomes, well, why was briefs and motions being submitted by Mullins, who only represents one party, and what does that mean for Choice, who hasn't been filing anything?
My question is, why was Sachs using an e-portal logged in under Mullins' account?
These are all,
It's all stamped. It says it right here.
Yeah, you don't have, that's why I keep saying, you don't have to believe anything I'm saying. It's literally all right there. So my whole reason to bring this to the 11th Circuit's attention is I'm not trying to, just cause a problem. I'm like, look, just tell me what's going on here. But something is wrong. Like, you don't have to be an attorney to see that something's clearly jacked up here. So, I said, here's all the problems. And what could be the outcome?
Not only
here?
do we have a response brief that was filed at 11:43 p.m., we also, a minute before they're late, at 11:59 p.m., and then a late one at 12:01 a.m.
Right. So
they're scrambling.
Oh, right. You think about that. You are late if you're at 12. So at 11:59, what the heck happened for you would wait until 11:59 to get your brief due for the 11th Circuit? Okay, you're exactly right. You nailed it on the head. They're scrambling. So then they file one at 11:59 and then another at 12:01, and that's late. And again, I brought this to the 11th Circuit's attention, and sure enough, they said denied. We don't care. We had oral argument. Long story short, they rule in favor of what the lower court did in the Southern District of Florida, the federal court, and they said, well, we agree with their well-reasoned order, and that's it, you lose. Here's the problem. The 11th Circuit doesn't have the authority to rule the way they did in that case, because the one caveat to
Today, but do they tomorrow?
Yeah, right. Well, no, I mean, this is something that was established actually in 1982. So there's something called the Federal Circuit Court of Appeals, okay? So any other case, it's all done by region. But if it's a patent issue, if it's a specific kind of substantial patent issue, it goes to a court that was created in 1982 called the Federal Circuit. That's right near the U.S. Supreme Court. It's in D.C. So I brought to their attention, and we've been bringing this word up, subject matter jurisdiction. Hey, 11th, you don't have the authority to rule the way you did. They don't. So I brought that to their attention. I said, transfer this to the 11th Circuit, transfer this to the Federal Circuit. You can't do this. They denied my motion. They said, again, without reason. They just said, motion to dismiss denied. So I filed a petition for rehearing en banc. And what that means is I believe that this issue is so important that I'm asking all the other judges who are in active service to say, hey, maybe we should all take a look at this again. Denied. So for the first time in history, I file a petition for mandamus, which means I'm asking another court to command another court to do something. So I said, I sought a petition for mandamus from the Federal Circuit to say, hey, 11th Circuit, Federal Circuit in DC, tell the 11th Circuit they don't have the authority to take yours away. So only the Federal Circuit has the authority to talk about and make rulings on substantive issues of patent law. But here's the thing, they are technically co-equal. So that's what's so dicey about this. And then the question goes back to your original question as to why does Judge Stevens want to keep this case? Why does Judge Lopane want to keep this case? Why does the 11th Circuit Court of Appeals want to keep a case that they know doesn't belong to them? Again, these guys are smarts, dude. These guys are the
most prestigious.
Right. I mean, and whenever these Supreme Court justices get picked, they usually come from these circuit courts of appeal. So they know what they're doing. So the question becomes, if they know that this case should have been transferred, why didn't they do it? So I petitioned the Federal Circuit, and they didn't disagree necessarily with my analysis. They said we lack the authority, while I disagree with this, but they said that we lack the authority to tell another co-equal branch or another co-equal court what to do. I can't tell them to give me their case.
Now what?
And this is where we're at. So they said if you have an issue with it, you have to go to the United States Supreme Court, and that's where we're left off right now.
How is this happening? We don't know.
And that's where it's left up right now. And I'm since I filed this, they have come back and they said they have denied my petition. But what they did say in big bold letters, they said this is not final until a motion for reconsideration has been filed, if we choose to do so, and ruled upon. So
7 cities, 7 counties, 4 appellate districts, the Florida Supreme Court, and now you're on your way to the U.S. Supreme Court, where we all know that they pick and choose what cases they hear. Just look at the 2020 presidential election. Mr. Ferguson, best of luck to you.
Appreciate it.
Of course.